the latest on the January 6th prosecutions.
This is Dr. David Schein, and welcome to Business Law 101.
Virtually all Americans are aware of the riot that took place on January 5th, 2021 in the Capitol. The stated purpose was to protest the election outcome, making Joe Biden the president over incumbent Donald Trump. That was only part of the story. Subsequent to that, more than 1,200 people have been charged. Of that number, more than 460 were in prison for their role in the Capitol attack. At least 718 guilty pleas have resulted, many of those with jail time. Then the U.S. Supreme Court ruled near the end of the 23-24 term that the charge of obstructing an official proceeding did not apply to the January 6th protests. The actual case involves a Pennsylvania law enforcement official. In a 6-3 vote, SCOTUS ruled that the law applied only to evidence tampering in official proceedings. This was the main charge against most of the January 6 protesters, so many pending prosecutions will need to be reviewed or dropped. More important, those that pled guilty without the benefit of this opinion may move to withdraw their pleas, which would clear their criminal record. So the question is, how did the FBI and other federal law enforcement round up all of these potential defendants? Well, there was not an organized sign-in at the Capitol that day where people signed their name and said what state they were from or whatever. So how'd they find them? Well, it turns out they used something called geofencing. That may now be falling apart due to recent ruling of the U.S. Fifth Circuit Court of Appeals. The ruling struck down geofencing warrants on the basis that they were an illegal dragnet. Warrants are supposed to be specific under the Fourth Amendment to the Constitution. These warrants were too broad, according to the Fifth Circuit, and violated the defendant's rights to be free from unreasonable search and seizure. This could impact at least 300 of those charged in the January 6th matter. For those who are interested, Judge Ho's concurring opinion is a powerful endorsement of that decision and explanation. While this may be brought up to SCOTUS next, it will be interesting to see where this goes. I think the current SCOTUS justices will agree with Judge Ho. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.